Cool. It doesn't come out well on this microphone. It sounds really bad. Oh, thank you, though.
Morning, Magistrate.
Morning.
Morning, everyone.
Morning, Your Honor.
Morning.
Let's see, morning.
Morning, Magistrate. J. CJC, is that Wayne County? If you can unmute your device, start your camera, please. Thank you. And then Pulowski, Marcin.
Yes, good morning, Your Magistrate. Magistrate, this is Trooper Petrovsky. I was trying to speak to one of the APAs that's going to be doing arraignment for Ramsey to give some extra information on the case.
Your Honor, that would
Okay.
be me.
Yes.
And
You want me to put you into a breakout room?
I
That'd be
would
great.
appreciate that. Thank you.
All right, go ahead, Trooper. Go ahead and accept the invitation. Okay. CJC for Wayne County, good morning.
Good morning.
Thank you. Who do you have there, sir?
So my name's Green Bass.
And Your Honor,
Thank you,
can we do
Mr.
a breakout room with Mr. Bass, please?
Yes. Yeah. Sheriff, are you going to also handle Eugene Carlson at that location?
Not at this location, Judge, but he'll be on in another unit.
Okay, thank you.
We're ready on Carlton, but we just need to speak to Mr. Bass. Thank you.
And you were going to speak to Mr. Bass?
Please, yes. Thank you.
Okay, so Mr. Bass, we're going to put you in a private breakout room with your attorney for an interview. Once they finish, we'll pursue with your arraignment. Go ahead and accept the invitation. Morning, DDC. Morning, DDC. At your pleasure. What's that? Yeah. Three, camera three, right, Kimberly? Camera three, right? Thanks. Oh, here we are. Good morning, sir. State your name, please.
Joe Baker.
Mr. Baker, good morning. Here for a couple of reasons. We're going to handle matters. First, you have warrants for your arrest for failing to appear. On these matters, Mr. Baker, you'll receive a personal bond, no dollar amount. I'm scheduling a pretrial date via Zoom. You must attend on Wednesday, December the 18th. That's at 8:30 a.m., 36th District Court, Judge Yancey. Understood?
Yes, sir.
Thank you. As with any criminal matter, Mr. Baker, you have a right to remain silent. Anything that you say orally or in writing can and will be used against you in a court of law. You do have the right to an attorney, one present at questioning and at all future proceedings. If you cannot afford an attorney, sir, the court will provide you one at the public's expense. Did you hear and understand your rights?
Yes, sir.
Thank you, sir. One moment. Baker, this is in regards to the following. Case number U 631-33110 took place on or about January 28th of 2010, entered a vacant dwelling without written authorization of the owner, editor 9399 Woodlawn. Case number U 236-02615, October the 19th of 2015, violation of city marijuana code. Ticket number SP 609026, March 17, 2016, count 1 drive while unlicensed, count 2 drive unregistered, untitled motor vehicle, count 3 improper plates. Case number 173653691, July the 5th of 2017. No operator's license on person. SP 1406740, December 27, 2022, count 1 drive while license suspended, count 2 no insurance misdemeanor in 2011 Chevy. SP 1497636, September the 6th, 2023, count 1 drive while license suspended, count 2 no insurance misdemeanor. SP 1544117, January 27, 2024, open alcohol in the motor vehicle as a driver. And SP 1616725, September 21st, 2024, drive while license suspended. During this bond, Mr. Baker, there's to be no driving and you're not to use any alcohol or illegal controlled substance. Understood?
Yes, sir.
These are all misdemeanor allegations that carry up to a $500 fine and or 93 days in jail is a maximum fine and penalty. Recall warrant set aside case not guilty plea is entered on your behalf. As a reminder, you'll have a pretrial via Zoom December 18th, 8:30, 36th District Court, Judge Yancey. Mr. Baker, you have an additional matter with the warrant for your arrest. State your full name again, please.
Good.
State your name one more time.
Bill Baker.
Thank you. And this is on case 2304494, People State of Michigan versus LaBelle Arthur Baker, also known as Derek Lampkin Jr., LaBelle Baker, LaBelle Arthur Baker. Parents for the people.
Thank you. Good morning. Steve Benson, P71917.
Good morning, Your Honor. For the record, Janice Stevenson appearing on behalf of LaBelle Baker, who stands mute, waives the reading of the information. After the plea of not guilty be entered on his behalf, Your Honor, Mr. Baker has been advised of his rights.
For waive formal reading, recall warrant set aside case. Good morning, Ms. Stevenson. I'm scheduling a pretrial day, Mr. Baker, via Zoom. You must attend December the 3rd. That's a Tuesday at 8:30 via Zoom, 36th District Court, Judge Bryan. Understood, Mr. Baker?
Yes, sir.
Thank you. Recall any warrant set aside case not guilty plea is entered as the bond from the people.
Magistrate failed to appear June 5th of this year. A capias was issued by Judge Bryan for 1,010%. We're actually going to be asking you to reinstitute the tether that you had originally issued to this defendant. This was your case on arraignment, June 15th of 23. You actually gave him a reasonably high personal bond. And after you see the allegations, I think it'll refresh your recollection as to why. But you also ended up giving him a tether as well. 2 months later, there was an order for removal of that tether. And at the next hearing, this defendant failed to appear. We're not going to be objecting to converting that cash capias to a personal, but we are going to be asking you to reinstitute the tether you had originally issued to this defendant over a year ago.
Thank you. Response, Ms. Stevens?
Your Honor, at this time, we'd ask the court to set bond at $500, 10%. Mr. Baker has given us an address separate from that of the complaining witness. We'd have no objection to a no contact condition, Your Honor.
Is he being held on any other matter?
I don't believe so, Your Honor.
I'll answer that. No.
Okay. Thank you both. Okay, so Mr. Baker, this is an assaultive allegation. I don't have any concerns regarding, well, I have minimal concerns regarding danger to the community, having not heard any convictions, assaultive or otherwise. I do have concerns regarding your intention to appear, as indicated by APA. So I arranged you back in 2022, I believe, and I gave you a personal bond. 2023, I apologize, last year in June. And I gave you a personal bond, and I told you to come to court. I repeated my court dates, and I also fitted you with a GPS tether, which was subsequently removed by another judge. And then you failed to appear apparently on June 6th of 2024. Given the capias history, I do find you to be a flight risk by clear and convincing evidence, having an opportunity already at a personal bond. I feel if I gave you the same personal bond, you would treat it as you have in the past and disregard the court's order and not show up. And for that reason, one second, Mr. Baker, I'm going to set a personal bond in the amount of $25,000 with the following conditions. Given your KPS history, you will be fit with a GPS tether prior to being released. That will have no time restrictions. During this bond, no use of alcohol, no illegal controlled substance. You're not to purchase or possess a firearm or any dangerous weapon. No contact with the Olympia Street address in the city of Detroit, and absolutely no contact with any complaining witness, including Miss Williams. That's no contact of any kind, orally in writing, through a third party at her place of residency, employment, or through any forms of social media. If you violate this court's order or tether in any way, going anywhere near Miss Williams, that's a violation of the court's bond, subject to get you picked up without a warrant, have your bond conditions forfeited and or revoked. Do you have any questions, sir, regarding your court dates or bond conditions? Any questions?
No, sir.
I seen you had your hand raised.
I was just, the reason that I had missed court, my mother passed away. My mother passed away, and then my father passed away 30 days right after that. That's the only reason that I missed court, sir.
When did they pass? And I'm sorry to hear about the loss of your family.
My mother passed in March, and my father passed in May. And we had to get all the money together. They passed 30 days apart. We had to get all the
Of this
money
year,
together.
2024?
Yes, sir.
Are we, AP, are we aware of any contact with any complaining witness or any officer since this date?
Oh, sir.
To answer your question, Magistrate, I don't believe so. I think this is a flight issue, though, and as much as I can appreciate the defendant's argument, and I've lost, a parent as well, since the failure to appear June 5th of 24, there hasn't been any attempts at rectification of this. Only this defendant now appearing before us some 5.5 months later.
And counsel, is there any, did he surrender himself, or how was he taken into custody?
Your Honor, it's my understanding that this was an arrest, not because of any new cases. I think it was a traffic stop, Your Honor, and again, we don't have any contact issues with the complaining witness.
Okay. All right, Mr. Baker, I do have those concerns. You're on a personal bond, and I do respect what you're telling the court. You had 5 months, sir, to surrender yourself, to address it. It sounds like you knew you had a court case going on. You had life difficulties, which I appreciate and do take into consideration, but you could have surrendered yourself. You have to address this matter, and you can't just decide on your own that you're not coming to court, and that's concerning because life happens, and life could happen between now and the next court date. And it sounds like your decision-making is that I need to deal with life and disregard court, which could have been rectified with you surrendering yourself once you've got everything together. If you missed your initial court date, which you should never miss, but it's been over 5 months, and then you had to be taken into custody on an unrelated stop, it sounds like, just to be brought to court. And so I do have those concerns by clear and convincing evidence. Bond is going to remain as stated, 25,000 personal, tether with no time restrictions. You have to show up to court, Mr. Baker, and resolve this in some form or fashion. Any questions on your court dates or bond conditions?
No, sir.
All right, good luck. Good morning, your name, please. Thank you, Mr. Gatt. You are here on case number 240444063, People State Admission versus Joseph Henry Gatt. Appearances.
Thank you, Magistrate. Steve Benson, P71917.
For the record, Your Honor, Janice Stevenson appearing on behalf of Joseph Gatt. He stands mute, waives the reading of the information, asks that a plea of guilty enter on his behalf. Mr. Gatt has been advised of his right.
Thank you both. Court will waive formal reading, recall warrant, set aside KPS, enter a not guilty plea on your behalf. I'm scheduling a pretrial, Mr. Gatt. You must attend in person downtown Detroit, 36th District Court at 421 Madison on December the 3rd, Tuesday at 8:30. Judge Austin Garrett. That will be in person. Understood? You understand that? Yes, okay. As the bond, the current KPS bond apparently was issued by Honorable Judge Austin Garrett, January 19, 2024, $750 cash, highlighted twice. Defendant cannot appear via Zoom. Defendant must post bond for the people.
Magistrate, we're going to ask you to continue that. It was the first hearing after arraignment that this defendant failed to appear. That was in January of this year. It's now in November. I don't believe the defendant gave himself up or tried to rectify this situation before today's date. He knows, why and how to come to court. Previously had a conviction for a criminal sexual conduct, 2nd degree, albeit some time ago, but he's gone through the criminal process before. Asking you to continue this.
Yeah, I don't think the court has the authority to modify this bond.
Yeah, it does.
Given the order of Judge Garrett that as stated, it's highlighted twice, defendant must post bond and cannot appear via Zoom. I'm going to follow the judge's previous order, the case is January 19th, 2024, finding Mr. Gatt by clear and convincing evidence to be a flight risk, having missed his court date as stated by the people or after being on a personal bond. The bond is, as stated by Judge Austin Garrett, will be continued $750 cash. During this bond, Mr. Gatt, there's no use of any alcohol, sir, no illegal controlled substance. You're not to purchase or possess a firearm or any dangerous weapon, no weapons. Do not go anywhere near the Burt Road in the city of Detroit, and no contact with any complaining witness, including Miss Benson. And that's no contact of any kind, orally in writing, to a third party at her place of residency and employment, or through any forms of social media. No contact with any complaining witness, including Miss Benson. And you must appear in person, not via Zoom, and you must post bond. Is that unaffordable, Ms. Stevens?
It is, Your Honor.
Thank you. I'm scheduling an unaffordable bond redetermination hearing, Mr. Gatt, 2 days from today on Thursday, November 21st via Zoom 2024 at 9 a.m. in front of Honorable Magistrate Honorable Judge Larry Williams will be Chief Judge McConaughey's courtroom. 2 days from today, if you cannot post that bond, you'll see the judge for a bond redetermination hearing, and you'll have opportunity to re-argue bond at that point if you're unable to post. That'll be 2 days from today at 9 a.m. Do you have any questions on your court dates or your bond conditions, Mr. Gatt? No? All right, show up to court, sir. Good luck. All right, DDC, 1 moment. We're going to handle Wayne County. We'll be right back to you. Are you ready on that, Ms. Stevenson?
Ready on both of the Wayne County cases.
Thank you. I think we got Mr. Bass first. Mr. Bass, state your full name.
Doreen Bass.
This is case number 24058-169, People State of Michigan versus Jareem Armand-Eric Bass. Parents for the people.
Good morning, Your Honor. Good morning, Ms. Stevens. Samuel A. Ragnan, P23-157 on behalf of the people.
Good morning,
Thank you.
Mr. Ragnan. For the record, Your Honor, Janice Stevenson appearing on behalf of Jerem Bass. He stands mute, waives the reading of the information as to the plea of not guilty and on his behalf. Mr. Bass has been advised of his rights, Your Honor.
Thank you. Court will recall any warrant set aside cases. I'm scheduling a review date, December the 3rd. That's a Tuesday in front of Judge Austin Garrett via Zoom.
Your
Understood,
Honor,
Mr. Bass?
I'm sorry.
Yep.
If it pleases the court, in that Mr. Bass is on remand from Judge Garrett, the information we have is that Judge Garrett wants to see Mr. Bass tomorrow.
How do you have that information?
That just, actually, I was with Judge Garrett, I don't know, about half an hour ago, but the updated information we have is that the remand continues, but he definitely wants him there tomorrow. I just got this information from my partner.
And who did they get it from? Judge Garrett?
I'm gonna assume that, Judge Garrett's clerk. So that would be Miss
Okay.
Lehman.
Okay, all right, so we'll schedule it tomorrow, November the 20th. Per Judge Garrett's clerk and giving your representation. And it's going to be scheduled for a review date, Mr. Best, tomorrow, November the 20th. The bond order indicates 7 days ago, remand, 65 days, Wayne County Jail, no early release, as the bond from the people.
Well, Your Honor, we certainly go along with what the Judge Garrett has ordered, and I think it's good to get to have a hearing tomorrow.
Stevenson.
Ask the court to follow Judge Garrett's order, Your Honor.
Okay. All right, Mr. Bass, per Judge Garrett's capious order on about November the 12th of 2024, you are going to be remanded in the custody given your capious history until for further proceedings. The scheduled date is tomorrow. During this bond, there's no contact with any complaining witness. Mr. Bass, the bond order also states 65 days, Wayne County Jail, no early release, but that will be addressed by Judge Garrett tomorrow. Today's the purpose of bond. Bond is going to be a remand, no contact with any complaining witness. Mr. Bass, do you have any questions, sir, on your court date or bond conditions?
No, I don't.
Okay, you're all set.
I'm
Thank you,
done.
John.
Stand up front.
Bro. Oh, this shit low. Oh, yeah.
Demetric LaRon Sharon.
Thank you, sir. 1 moment.
Somebody else.
1 moment at Wayne County. We're gonna handle you in a second. All right, DDC in the white t-shirt, your name?
My name is Demetric LaRon Sharon.
Thank you, Mr. Sherman. Good morning. You're here for a couple of reasons. We'll go through one at a time. First, you have warrants for your arrest, sir, for failing to appear at the 36th District Court. On these matters, Mr. Sherman, you'll receive a personal bond, no dollar amount. Scheduling a pretrial date via Zoom, you must attend on December the 17th. That's a Tuesday via Zoom at 8:30, 36th District Court, Judge Archer. Understood?
Yes, Your Honor.
All right, Mr. Sherman, as with any criminal matter, you have a right to remain silent. Anything that you say orally or in writing can and will be used against you in the court of law. You do have the right to an attorney, one present at questioning and at all future proceedings. If you cannot afford an attorney, Mr. Sherman, the court will appoint you one at the public's expense. Did you hear and understand your rights, sir?
Yes, Your Honor.
Thank you. Karen, this is in regards to ticket numbers 16286-137, May the 18th, 2016. No operator's license on person. Ticket number 18412-718, January 15th of 2018. Driveway license suspended. Count 1, count 2, unregistered, untitled motor vehicle. Count 3, no vehicle insurance on a 08 Mercury. Ticket number 194411155, August 29th, 2019. Driveway license suspended. And SP 1326723, March 18th, 2022. Count 1, only driveway license suspended. These are all misdemeanor allegations that carry up to a $500 fine and or 93 days in jail as a maximum fine and penalty. Recall your warrant, set aside capious, enter a not guilty plea on your behalf. These matters, as a reminder, will be set for a pretrial, Judge Archer, December 17th, 8:30 at the 36th District Court. Mr. Sherman, full name again, sir. You have another warrant for your arrest on a separate matter.
Demetric LaRon Sharon.
This is case 200606161, People State of Michigan versus Demetric LaRon Shern, identifying the complainant as defendant 2, also known as Demetric Shern, parents for the people.
Samuel A. Ragnan, Your Honor, but we're not going to be appearing on this matter since it's a felony.
Okay.
We don't appear.
Thanks for the reminder. All right, thank you. And Ms. Stevenson, appearance.
Yes, Your Honor, for the record, Janice Stevenson appearing on behalf of Demetric Shern. He stands mute, waives a reading of the information, asks that a plea of not guilty be entered on his behalf. Mr. Shern has been advised of his rights, Your Honor.
Thank you, counsel. For a waive formal reading and a plea of not guilty. I'm recalling warrants set aside capious. Mr. Shern, I'm scheduling 2 court dates. You must attend both of them. Probable cause via Zoom, November 26th, 8:30, 36th District Court, Judge Robbins. You have a right to a preliminary examination in person following Tuesday, both on a Tuesday, December the 3rd, 8:30, Judge Taylor at the 36th District Court. Understood, Mr. Shern?
Yes, Your Honor.
Thank you. As to the KPS bond, Ms. Stevenson?
Your Honor, we have filed an emergency bond motion. We have not yet gotten a response to that. At this point, the $10,000 cash bond ordered on December 7, 2020 is unaffordable.
Thank you. So, Mr. Shern, when you missed court, as stated on or about December the 7th of 2020, Judge King put a warrant for your arrest and placed a bond in the amount of $10,000 cash or surety. I have no authority as a magistrate to change that bond. You've heard your counsel indicate that she's filed an emergency motion, her office, seeking reduction of that bond. If we get a response, we'll take it from there. But at this point, my understanding is no response. So without authority to change that bond, that will be continued. Bond will be set as stated, 10,000 cash or surety. During this bond, there is no use of any alcohol, no illegal controlled substance, and you're not to purchase or possess a firearm or any dangerous weapon, no weapons. Mr. Shern, your counsel indicated that's unaffordable, so I'm scheduling an unaffordable bond redetermination hearing 2 days from today, Thursday, November 21st, 2024 at 9 a.m. via Zoom. That'll be Chief Judge McConaughey's courtroom. If you're unable to post that bond, you'll see a judge or someone in his stead and have opportunity to re-argue bond at that point. Do you have any questions, Mr. Shern, on your court dates or bond conditions?
Yeah, so the $10,000 bond, if I was to get a bail bondsman, that is that how I could possibly afford that? Is that how that would work?
That's an option. Yes, you're allowed. This is a cash or surety bond, so you are allowed to get a bondsman. That's an option.
Okay, but it's no 10%.
No, 10%.
Okay.
And Mr. Shern, we did file a motion. We're waiting for a response on a motion to reduce the bond, sir.
Okay, and it's not possible I could be get like a higher personal bond?
You could. Your counsel has said, I have no authority to change the bond. So I don't have, so your counsel has reached out to the judge who has that authority. If they hear back, we'll follow that judge's order. It could be a personal bond or it could be left the same, but that's your options. And if it's left the same and you're not able to post, you'll see a judge in 2 days for a redetermination hearing.
Okay, thank you, Your Honor.
You're welcome, sir. All right, DDC, one moment. We have one other individual at Wayne County, and then the rest will be with you this morning. Thank you. Your name at Wayne County, is that Mr. Carlton?
Lieutenant Carlton.
Thank you. This is case 2406052, People State Commission versus Eugene Alexander Carlton, also as Eugene Jennings, Eugene Alexander Jennings, Eugene Carlton. Eugene, no middle name, Carlton. Appearances for the people.
Emily Ragland for the people, Your Honor.
Janice Stevenson, on behalf of Eugene Carlton, he stands mute, waives the reading of the information, asks that a plea of not guilty enter on his behalf. Mr. Carlton has been advised of his rights, Your Honor.
Thank you. Court waive formal reading, enter plea of not guilty. Mr. Carlton, I'm scheduling 2 court dates, sir. You must attend both of them. Probable cause via Zoom, December the 2nd. That's a Monday at 8. You have a right to a preliminary examination in person the following Monday, December 9th, 8:30, 36th District Court, Judge Giles. Understood, Carlton? Understand your court date and time, sir?
Yes, I have a question.
Go ahead.
This case was just dismissed on the 14th. So I'm back here.
Okay, I don't see it being dismissed, Mr. Carlton. If you have any paperwork or other, let me finish. This appears to be an open case. It's a felony allegation.
It was dismissed.
What's that?
It was dismissed in 30.
Okay.
Your Honor, please report. It looks like it was dismissed on November 13th and then on November 14th, Your Honor.
For the clarification, that's what I was getting. It looks like they reissued it, Mr. Carlton, the day after it was dismissed. So it's back open. So make sure and show up to court those 2 days. You have to show up. Understood?
I was on a personal bond on that matter.
Understood? I understand, Mr. Carlton. No doubt this is a stressful for you. We're going to get to bond arguments, so just listen closely. And then if you have any other questions, we can address them at that point. Okay? Go ahead, from the people.
Well, Your Honor, people are going to ask for $50,000 cash surety bond tether home arrest on this case. And the reason we're asking for it, even though there's a breaking and entering, there's evidence of 3 breaking and entering.
Well, this is not a breaking and entering. Are we on the right matter? The allegations receiving and concealing.
Oh, I'm sorry. Yes. My apologies. But Your Honor, the situation is, let me tell you about this case.
Well, I don't, before you get into the argument, counsel, was he on a personal bond on this matter before it was dismissed?
I have no idea. He has 2 other carjacking cases, separate cases, where he has a $500,000 cash bond that are pending with the exam set for, let's see, 11/25/24 is one of the cases, and the other case is set for exam on, I think,
The same day.
same date. So
And I-
we got those 2 cases, which, excuse me,
Don't come.
But there's 7 charges in one and 6 in another, assault with intent to murder, numerous charges, assaultive charges. And I think any bond given to this defendant, no matter what the charge is, I think he's a danger. I don't know if he's going to get out or not, but we never know if those cases are dismissed and all of a sudden he's sitting there with a personal bond on something else. So you don't know what's going to happen. But looking at the totality of circumstances, I think he is a danger.
Any assaulted convictions? I see he has a number of convictions, pending allegations. Any assaulted convictions?
No, receiving, concealing back in 2016, breaking and entering in 2014, and another attempt break and entering in 2013. That's what I have.
Thank you.
So I'm asking for a cash bond in this matter. And the evidence in this case is pretty compelling. The defendant allegedly broke into a MS Electric, it's called. A number of items were stolen, a number of ladders and different tools. The complainant estimated about $3,000 in items were stolen. The next day, those items appeared on the Facebook Marketplace and said to contact his father, Larry Carlton,
That's not my.
who's 73.
Mr. Carlton, be quiet, please. Thank you. Keep continuing.
The complaining witness saw this and went to the police and told them about it. They subsequently find out who this is and they get a search warrant. They go to the home and they find things that were stolen at MS Electric, not only on the October 21st, but also from breaking and entering at that location on July 8th, 2024 and October 14th, 2024. So there was items found from all 3 of these break-ins, but it's total $1,870 in stolen items. So, Your Honor, I believe that my biggest concern here is only about what could happen with this bond on this case, and I think a cash bond is appropriate. Whatever you think. Thank you.
Thank you for your advocacy and argument. One moment, Mr. Carlton. You have a very good attorney. Let her speak, and then you can say anything or ask any questions. But I recommend let's let her speak real quick, okay? Or let her take her time and make argument. And Ms. Stevenson, a couple questions. I think you know what I'm going to ask. He was on a personal bond, and did he ever miss court or have any assaultive crimes or any allegations in the pending?
None, Your Honor. He never missed a court date. The matter was dismissed at exam, I think on an evidentiary issue. And this is a non-assaultive charge, so he's still presumed innocent of it. It was $25,000 personal, and he didn't have any violations of that. So I'm asking that bond not exceed $25,000 personal. I think that, again, he's still innocent until proven guilty of all the charges.
Understood. Okay, so Mr. Carlton, you've heard, I know you want to speak, but just let me, and then you'll be your chance. Okay, so Mr. Carlton, I've heard advocacy from both parties. I do have concerns. You have pending matters, but they're not convictions. They're allegations. At this stage, you're innocent until proven guilty, as reminded by your counsel. You have no assaulted convictions I'm aware of. And this matter is a reissue. You were apparently on a $25,000 personal bond previously. I'm unaware that you missed any court dates on this. I'm unaware that you picked up any assault of convictions in the meantime. Assault of convictions in your lifetime. This is a serious allegation. I have concerns. You have pending matters. It sounds like you're on a substantial bond on those other matters. And given that you were on a previous personal bond on this, it's a reissue. No criminal history or capious in the meantime or on this matter. And this being a serious, though non-assaultive allegation, courts following your counsel's recommendation, Mr. Carlton, I'm going to reinstate your $25,000 personal bond on this matter. During your bond, there's no use of any alcohol, no illegal controlled substance. You're not to purchase or possess a firearm or any dangerous weapon. There's to be no driving of any motor vehicles, no contact with the Avery Street in the city of Detroit, and no contact with any complaining witness, including Mr. D'Agostino. No contact means no contact of any kind, orally, in writing, through a third party at his place of residency, employment, or through any forms of social media. No contact with any complaining witness. Now, Mr. Carlton, your turn. You have any questions? It's a personal bond with the conditions I've stated. You are being recorded. Is the prosecutor here? Any questions on your court date or your bond conditions?
Everything was great, Your Honor.
Okay. All right, Mr. Carlton, show up to court.
Thank you, Your Honor.
Thank you. All right, DDC, thank you. At your pleasure. Thank you. I think everything else is with your facility, DDC. Thanks.
Anya Hunter.
Thank you, Mr. Hunter. And, good morning to you. You're on case 24060160160, People State of Michigan versus Armani Deshaun Hunter, identified in the complaint as defendant 2, also known as Armani Hunter. Parents for the people.
Thank you, Magistrate. Steve Benson, P 71917.
Thank you.
Janice Stevenson on behalf of Armani Hunter. He stands, lays a reading of the information after the plea of not guilty be entered on his behalf. Mr. Hunter has been advised of his rights, Your Honor.
Thank you both for a waive formal reading and our plea of not guilty. Mr. Hunter, I'm scheduling 2 court dates. You must attend both of them. Probable cause via Zoom, December the 2nd, 8:30, 36th District Court, Judge Taylor. You have a right to a preliminary examination in person, December the 9th, both on a Monday, 8:30, 36th District Court, Judge Taylor. Understood, Mr. Hunter?
Okay.
Is that a yes? You understand those court dates?
Yes, sir. Yes,
Thank
sir.
you, sir. Not guilty. Please enter it on your behalf. Waive formal reading as to bond from the people.
Magistrate, just for housekeeping, we had defendant 1 arraigned in the arraignment's courtroom October 28th of 24 in front of the Honorable Magistrate Boyer. Defendant 1, Mr. Davis, was given a $250,000 cash surety bond with tether house arrest. That went up to redetermination 2 days later, and the Honorable Chief Judge McConico ended up continuing that bond. He's got an exam that's scheduled for December 2nd of 24. That's all in regards to defendant 1. In addition to that, one other side note regarding defendant 1, he didn't have any priors upon being given that $250,000 cash surety bond with tether house arrest. The 2 lead charges for this defendant are AWIM. We're going to be asking for a $250,000 cash surety bond as well as tether house arrest. Just a couple of highlights. I'm sure you've gone over the allegations here. We have a defendant who allegedly participated in an initial beating of a homeless person right down the road from the courthouse in front of Hollywood Casino, only to leave himself and 2 others to go get defendant's vehicle, to get in that vehicle to proceed back to where they had just beaten that individual and then shoot him before fleeing. We find the defendant a danger. We find this incident highly assaultive. Parts of this incident allegedly were captured by video. As a direct result, we feel as though this is what a cash bond is for, to protect the community from people like this defendant. Respectfully, we're asking for that cash with home confinement.
Your Honor, Mr. Hunter is 26 years old with no criminal history that I'm aware of. We don't have very fresh allegations here. There's no indication that Mr. Hunter changed dresses recently or anything of that nature. He would continue to have no contact with the complaining witness. He is seeking employment, Your Honor, so he does not have money to post his bond. But we don't believe that Mr. Hunter presents any risk of flight. We would ask the court to consider a high personal bond with a GPS tether, Your Honor. Absolutely no contact with the complaining witness.
Thank you both. Okay. And then APA, what are Mr. Hunter's priors again?
I didn't mention any priors, but I also didn't mention the fact that he's got a felony warrant out of Troy 52-4 for felony larceny, as well as financial transactions with the date of warrant March 22nd of 24. Troy wants him. They're going to pick him up on that as well. But just like the previous defendant one, he had no priors.
Okay. All right, Mr. Davis, I've heard advocacy from both parties. Taking into consideration any employment status presented by counsel as it relates to ability to post bond, you have apparent ties to the community. I've reviewed the investigator's report and the nature of these charges, which are extremely serious, specifically counts 1 and 2, both possibility of life in prison or any number of years. There's allegations in the investigator's report that are extremely concerning regarding the safety of the public, as highlighted by the APA. It's alleged, and portion of this is apparently caught on security footage, that you, in concert with the co-defendants, assaulted a homeless individual. Apparently, was the complaining witness was told to stay right there. We'll be right back. Security footage captured portion of this incident where, as stated by APA, is alleged that individuals came back and shot the complaining witness after assaulting the individual. Court does find there is a high likelihood of conviction. By the court, in order to set an unaffordable cash bond, must find by clear and convincing evidence you are either a flight risk and or a danger to the public or a particular individual. Here, it's apparently that you don't know this complaining witness, and that's concerning. It's apparently an innocent, random individual that was homeless, according to the investigator's report at the time. And the decisions alleged to have been made by you and co-defendant were not only to assault this homeless individual, which I don't see anything in the investigator's report regarding any actions by the complaining witness. And then came back to the location and shot the individual. The court finds that by clear and convincing evidence, given a likelihood of conviction, you are a danger to the public at whole, and finds a personal or nominal bond will not adequately protect their safety. Therefore, the court is setting an intentional unaffordable cash bond as recommended by the people of $250,000 cash or surety. During this bond, there is no use of alcohol, no illegal controlled substance. You're not to purchase or possess a firearm or any dangerous weapon. Do not go anywhere near Hollywood Casino in Greektown, downtown Detroit. No contact with any complaining witness, and that includes Mr. Bailey or Ms. Small. No contact is no contact of any kind, orally in writing, through a third party at their place of residency, employment, or through any forms of social media. And no weapons. You're not to purchase or possess a firearm or any dangerous weapon. Prior to being released, given the concerns the court has regarding the safety of the public, you'll be filled with the GPS tether that'll place you under house arrest. You're not to leave your home any reason unless court ordered or medical. If you go anywhere near the complaining witness or leave your home for any reason otherwise, it's a violation of the court's bond, subject to get you picked up without a warrant, have your bond conditions forfeited and or revoked. Counsel, do you have it? Is this unaffordable?
It is, Your Honor.
Thank you. The court, for that reason, is setting an unaffordable bond redetermination hearing Mr. Hunter 2 days from today. Chief Judge McConaughey's courtroom, November 21st, 2024 at 9 a.m. via Zoom. If you're unable to post that bond, you'll see the chief judge or someone in his stead at that date, and you'll have opportunity to re-argue bond. Do you have any questions on your court dates or bond conditions, Mr. Hunter?
Yes, sir.
All right, show up to court. Morning, your name? Your name, sir?
Carlo Young.
Thank you, Mr. Young. Mr. Young, you're here on case number 240606117. People State of Michigan was Carlo Nelson Young for the people. And good morning, APA Coyle.
Good morning, Your Honor. Good morning, Ms. Stevenson. Lisa Coyle appearing on behalf of the people.
Good morning, Ms. Coyle. For the record, Janice Stevenson appearing on behalf of Carlo Young. He stands with waives the reading of the information, asks for the plea of not guilty, and on his behalf, Mr. Young has been advised of his rights, Your Honor.
Thank you, Ms. Stevenson. Court will waive formal reading under plea of not guilty. Mr. Young, I'm scheduling 2 court dates. You must attend both of them. You have a probable cause via Zoom, November 26th. That's a Tuesday, 8:30, 36th District Court, Judge Robbins. You have a right to a preliminary examination. You must attend in person the following Tuesday, December the 3rd, 8:30, 36th District Court, Judge Taylor. The last Tuesday in November, the first Tuesday in December. Understood?
Say it again, one more time.
This November the 26th via Zoom, December the 3rd in person, both at 8:30, 36th District Court. Understood?
Yes, sir.
Thank you, sir. It's the bond from the people.
Your Honor, the people have no objection to a $5,000 personal bond in this matter. I don't see an adult record other than a drag racing from 2020. He's 21 years old. This is non-assaultive.
Ask the court to follow the people's recommendation, Your Honor. Mr. Young is working at this time, Your Honor. He did finish high school, doesn't have any adult criminal history, and we would, again, ask the court to follow the people's recommendation.
Thank you. Mr. Young, this is a very serious felony allegation. You have no criminal history that I'm aware of that's stated by both parties. Your counsel's advocated well on your behalf. After review the investigator's report, I'm going to follow their recommendation. Bond will be set, given the nature of the charge, at $5,000 personal bond. During this bond, there's no use of any alcohol, no illegal controlled substance. You're not to purchase or possess a firearm or any dangerous weapon, no weapons. And I want you to continue with your employment. Stay employed, and good luck with your employment. I hope that works out well for you. Stay employed. Mr. Young, do you have any questions on your court dates or bond conditions?
No, thank you.
Morning, your name? Thank you. You say Jamanica Quentin Harris, is that correct?
Demacia Quentin Harris.
Thank you. This is case 24060-622, People State of Michigan versus Jamancia Quentin Harris, also known as Jamancia Harris appearances.
Lisa Coyle appearing on behalf of the people.
Janice Stevenson appearing on behalf of Jamancia Harris, who stands mute, waives the reading of the information, asks that a plea of not guilty be entered on his behalf. Mr. Harris has been advised of his rights, Your Honor.
Thank you. Court waive formal reading under plea of not guilty. Mr. Harris, I'm scheduling 2 court dates, sir. You must attend both of them. A probable cause via Zoom, November 26th. That's a Tuesday at 8:30, 36th District Court, Judge Robbins. You have a right to a preliminary examination in person the following Tuesday, 36th District Court, Judge Taylor, 8:30 a.m. Understood, Mr. Harris? Yes?
Yes.
Thank you. Not guilty. Please enter on your behalf, waive formal reading as the bond from the people.
Your Honor, obviously no flight risk based on the unusual facts of this case, non-assaultive, no objection to a $5,000 personal bond.
Thank you.
Your Honor, ask the no risk of flight here, Your Honor. It's non-assaultive.
Thank you. Mr. Harris, no criminal history, capious history that I'm aware of. This is a given the nature of the allegation. Bond is going to be set off. No illegal controlled substance. You're not to purchase or possess a firearm or any dangerous weapon. No weapons. Do you have any questions, Mr. Harris, on your court dates or your bond conditions, sir? All right, good luck, Mr. Harris. Show up, sir.
Thank you.
Thank you. Good morning, your name?
Rodarius Cornelius Davis.
Thank you, Mr. Davis. You're here for a couple of reasons, Mr. Davis. We're gonna go through them one at a time. First, you have a few warrants for your arrest for failing to appear at the 36th District Court. On those matters, Mr. Davis, you'll receive a personal bond, no dollar amount. Scheduling a pretrial via Zoom, you must attend December the 17th. That's a Tuesday, 8:30, 36th District Court, Judge Sherman. Understood?
Yes, sir.
Thank you, sir. As with any criminal matter, you have a right to remain silent. Anything that you say orally or in writing can and will be used against you in the court of law. You have the right to an attorney at questioning and at all future proceedings. If you cannot afford an attorney, Mr. Davis, the court will provide you one at the public's expense. Did you hear and understand your rights, sir?
Yes, sir.
Thank you, Mr. Davis. The ticket number is SP 1536959, January 4th, 2024, allowing an unlicensed driver to operate your 2014 Chevy SP 1561875. March the 8th of 2024, count 1, drive while license suspended, count 2, no insurance misdemeanor on 2014 Chevy. These are misdemeanor allegations that carry up to a $500 fine and or 93 days in jail as a maximum fine and penalty. Recall the warrant, set aside cases not guilty, please entered on your behalf. As a reminder, Mr. Davis, pre-trial date you must attend and will schedule via Zoom, December the 17th, Tuesday, 8:30, Judge Sherman at the 36th District Court. Mr. Davis, you have an additional matter. State your full name again, please.
Rodarius Cornelius Davis.
Thank you. And this is case 2406061, People State of Michigan versus Rodarius Cornelius Davis, also known as Rodarius Cornelius Davis, appearance for the people.
Emily Reagan for the people, Your Honor.
Janice Stevenson, on behalf of Rodarius Davis, he stands mute, waives the reading of the information. Asks a plea of not guilty, enter on his behalf. Mr. Davis advises his rights, Your Honor.
Thank you. Court waive formal reading and plea of not guilty. On this matter, Mr. Davis, I'm scheduling 2 court dates. You must attend both of them. Probable cause via Zoom, November 26th. That's a Tuesday, 8:30, 36th District Court, Judge Robbins. You have a right to a preliminary examination taking place in person the following Tuesday, December the 3rd, 8:30, 36th District Court, Judge Giles. Understood, Mr. Davis?
Yes, sir.
Thank you, sir. Not guilty, please enter on your behalf, waive formal reading as the bond from the people.
Ben has no prior offenses, Your Honor. We're going to ask for $10,000 personal bond.
Thank you.
Hopefully it won't.
As for personal bond, Your Honor, no prior criminal history. Mr. Davis is seeking employment at this time. It's non-essential charge.
Thank you. Okay, Mr. Davis, I'm unaware that you've had any criminal history, assaultive or otherwise. I've reviewed the investigator's report. This is a very serious allegation. It is non-assaultive. For those reasons and given the nature of the allegation, Mr. Davis, bond is going to be set as recommended in part by both parties, $5,000 personal bond. During this bond, no alcohol, no illegal controlled substance, and you are not to purchase or possess a firearm or any dangerous weapon. No weapon. Do you have any questions, Mr. Davis, on your court dates or bond conditions?
No, sir. I think I have one question. Will everything get mailed out to me over there?
Will it be what? Mailed to you? No.
Never mind. Okay.
Okay, and if, Mr. Davis, I want to be clear, if you get court paperwork, you don't, you lose it, it's your responsibility to show up. I've told you your court dates a couple of times. I'll remind you that this matter is the last Tuesday, November 1st, Tuesday in December. You can always come down to the 36th District Court. You can look on our court's website. You can call your attorney. But what you cannot do is miss any court dates, because then you'd be likely to get taken into custody and locked up just for missing a court date, and that would be regardless of your guilt or innocence. So you have to take those court dates extremely seriously. If you lose or forget, it's your responsibility to figure it out. Is that understood? No
Yes,
excuse.
sir.
All right, good luck. Mr. Davis.
Don't come back. Any more cases? Thank you, Aaron.
Thank you. Your name, sir?
Giovanni Gary Gully.
Good morning, Mr. Gully. Here for a couple of reasons. We'll go through them one at a time. First, you have a warrant for your arrest for failing to appear at the 36th District Court. Mr. Gully, on this matter, you are going to receive a personal bond, no dollar amount. Scheduling a pretrial date, you must attend via Zoom on December the 17th. That's a Tuesday at 8:30, 36th District Court, Judge Perkins. Understood?
Yes, sir.
Thank you. As with any criminal matter, Mr. Gully, you have a right to remain silent. Anything that you say orally or in writing can and will be used against you in the court of law. You have the right to an attorney at questioning and at all future proceedings. If you cannot afford an attorney, the court will provide you one at the public's expense. Did you hear and understand your rights, Mr. Gully?
Understand.
Thank you. And this is on ticket number SP 1474510, July 1st, 2023, no insurance, a misdemeanor on a 2016 Jeep. It's a misdemeanor allegation that carries up to a $500 fine and or 93 days in jail as a maximum fine and penalty. Recall warrant set aside capious, not guilty, please continued and entered. As a reminder, sir, pretrial via Zoom, December 17th, Judge Perkins at 8:30. Mr. Gully, state your full name again. You have an additional case.
Giovanni Gary Gully.
Thank you. This case 240454119, People State Commissioner versus Giovanni Gary Gully, appearance for the people.
Thank you, Magistrate. Steve Vincent, P 71917.
Janice Stevenson appearing on behalf of Giovanni Gully. He stands mute, waives the reading of the information as to the plea of not guilty. On his behalf, Mr. Gully has been advised of his rights, Your Honor.
Thank you. For a waive formal reading and a plea of not guilty, Mr. Gully, I'm scheduling a pretrial date via Zoom. You must attend on Tuesday, December the 3rd at 8:30, 36th District Court, Judge Austin Garrett. Understood?
Yes, sir.
Thank you, sir. Not guilty, please enter it as the bond from the people.
Magistrate, this defendant has no prior convictions, criminal convictions, so therefore I'm not going to be asking for cash. I won't object to a personal. However, I am going to be asking for a tether as well as a curfew. The reason why this warrant was entered, as you can see, I'm sure as well as Ms. Stevenson would note to you, October 31st of 2024 was because the complaining witness ended up contacting the APA in October, letting them know, the APA assigned to this case, that she is in fear as a direct result of this defendant. And just touching on the allegations here, allegedly the incident happened June 30th of 2024. And just to encapsulate it, because it's kind of short and sweet, but it packs a punch. Here, the defendant allegedly beats the mother of his child in front of their child. And then after he gets done beating her, he threatens to shoot her. Judge, considering the dangerous nature of what defendant allegedly did to this complaining witness, and then the threat of death subsequent to this, I guess it was a back and forth internally between prosecutors as to whether or not he was going to be charged with the GBH. Because as you can see, there was ultimately they decided on the DV. Because this complaining witness is in fear, continues to be in fear, as well as the assaultive nature and the threats, we do feel as though this defendant is a danger to the complaining witness. Again, not going to be asking for the cash because no priors, but we think monitorization is necessary.
Your Honor.
Okay, and one second, Mr. Gully. You'll have your chance, but let us all finish. You have an attorney here, and then you'll have your opportunity, but just listen closely. Your question may be answered. You'll have your opportunity if not. APA, I guess I don't, I'm sure you don't know the answer. I've asked you this many times. There was over 4 months. Do we have any reason why this took 4 months to charge? And do you have any information that there's been contact since that date? You heard you say that APA notes she's in fear, but any assault of contact alleged since that date or any charges?
I have the notes in front of me. And I had actually read the witness statements as well. When she was first investigated by the police in early July, she had actually told them in the beginning that she did not want to prosecute this individual, only to follow up in subsequent investigation July 23rd, where she made a secondary statement where she said that she was in fear and she did want to continue. And then to follow up that July 23rd statement to the police, the complainant, the individual here, the complaining witness, ended up speaking to the prosecutor's office, where she had told them that she was still in fear. And this was October 17th of this year. She wanted to know the status of the case.
May I also mention that we are.
Mr. Gully, please don't say anything right now. This is a prosecutor who's right here on the screen with you. Please don't say anything.
Okay.
So,
All right, thank you.
I can appreciate where you're coming from, but I think there was a back and forth between, at least initially, with that follow-up by the police in later July, and then this subsequent communication between the individual and the prosecutor's office. There was a holdup. I mean,
Yeah. You see my concerns. My two concerns, as I think you know, are this 4-month lag by the prosecutor's office on the decision to charge on a 93-day misdemeanor with no priors, and then also the allegations, the investigators report, very serious, substantial assaultive allegations, but it's also alleged that officers observed no injury to the complaining witness. So that's a little conflicting than the testimony. No injuries are alleged to observe, and it took a substantial time. Those are my concerns.
Even whether or not there are visible injuries, the allegations plus the idea we have an individual doing this in front of a child and with the threat of death. Ultimately, that's why I'm asking for the monitorization.
I understood, and I understand, it would ring more true if this allegation had taken place or if the people would have shared your view and brought some type of charges with it before a 4-month period. But now we're sitting at 5 months since this incident, and you said these are allegations, no history, so anyway, those are my concerns. Anything else from the people?
No, I appreciate you hearing me out.
Thank you for your advocacy, Ms. Stevenson.
Your Honor, Mr. Gully, once he learned that this matter was outstanding, I think we were doing a job search or something like that. He found out that the warrant was outstanding on his own, and then he turned himself in today. So, despite the people's concerns, we understand that these are very serious allegations, but that's all they are at this point. And Mr. Gully presents no risk of flight. Is trying to handle, as soon as he found out that the warrant finally was signed and the matter was outstanding, he took it upon himself not to have to wait to get arrested, turn himself in. Mr. Gully is employed at this time. He does have the one child in this community. He's using his income to help support that child. We would ask the court to consider a personal bond. We'd ask the court not to keep Mr. Gully off his job any longer than
he doesn't live with the complaining witness. Is that accurate?
That is accurate, Your Honor. And we want him to be able to get back to work.
All right, thank you. All right, Mr. Gully, your counsel, both counsels have advocated well. Your counsel on your behalf. You've heard a portion of my position. This is a very serious allegation. It's charged as a 93-day misdemeanor. Allegation took place back in June. People didn't submit the warrant until end of October. And then during that period of time and in your lifetime, I'm unaware that you've had any assaultive history, no capious history, no criminal convictions that I'm aware of. And in the meantime, apparently, according to your counsel, you've surrendered yourself when you found out about this warrant. And this is very important to the court. That alleviates some of the concerns that I may have had given these very serious allegations as stated by the people, throwing weapons, choking this complaining witness, hitting her head, allegations of threatening to shoot her. Noted roughly upon investigation by the officers, 2 hours and 25 minutes after this allegation, the officers indicated no injuries to the complainant and no harm alleged to any minor children that may have been in the proximity. Given your lack of history, the nature of this charge, this allegation at this point, the time that has lapsed, and you surrendering yourself to the court, to the authorities to address this allegation, Also, consider your employment status as relates to ability to post bond will be set as recommended by your council, $35,000 personal bond. Mr. Gully, during this bond, there's no use of any alcohol, no illegal controlled substance. You're not to purchase or possess a firearm or any dangerous weapon. You're not to go at no contact with the complaining witness or any complaining witness, including Ms. McCoy. No contact is no contact of any kind, orally and writing through a third party at her place of residency or through any forms of social media. No contact with Ms. McCoy. And you're not to go anywhere near the Beaconsfield Avenue in Grosse Pointe during this bond. And I want you to continue with your employment. Good luck with your employment. And as an order of the court, you're to continue while on bond. Do you have any questions on your court date or bond conditions, sir?
Judge, we have a custody battle, which I am, my daughter's on my insurance. I am the
So
legal.
Mr. Gully, do you have any questions about when you're supposed to go to court?
I have a question containing because we do meet with.
Okay,
Jane,
so
my
listen,
daughter.
let me take care of that part, but, I just want to make sure you know when you're supposed to go to court. Do you know when you're supposed to go to court, Mr. Gully?
December 7th at 8 a.m.
December 3rd via Zoom.
December 3rd.
Judge Austin
December
Garrett. That's a Tuesday. Okay,
That's right.
counsel.
Yes, Your Honor, based upon, the fact that there is those court hearings that are going on, would the court consider no assaultive contact for the purposes of facilitating, exchange of the child and attendance at any family court hearing?
No, as always, follow any circuit court order. So if there's a circuit court order by the family court in effect regarding any exchanging of the child, follow that order. But during this bond, unless a circuit court judge orders otherwise, or another judge orders otherwise, you're to have no contact for any reason, not to reach out to facilitate anything, child included. Is that understood? No contact at this point with Ms. McCoy unless court ordered. Clear? Thank you. Anything further from either counsels?
No.
Nothing on behalf of Mr. Gully. Thank you, Your Honor.
Thank you both. Your name?
Answer my Otis Senior.
Thank you, Mr. Otis Senior. Here on case 24060-620, People State Commissioners Antar Ahmad Otis, Antar A. Otis, also known as Antar A. Otis, Antar Otis, parents for the people.
Thank you, Magistrate. Good morning. Steve Benson for the people.
Morning.
For the record, Your Honor, Janice Stevenson appearing on behalf of Antar Otis. Your Honor, Mr. Otis does stand mute, who waives the reading of the information. We ask that a plea of not guilty enter on his behalf. Mr. Otis, has been, I believe he's been advised of his rights, Your Honor.
Yes. Have you been advised of your constitutional rights, Mr. Otis?
Yeah, my rights remain silent, you know that?
Yes.
Yeah, we just remain silent, sir.
Have you been advised of your rights? Do you want, if not, I can tell them to you.
You can re-advise me up in there, sir.
Okay, all right, sir, Mr. Otis, you have a right to remain silent. Anything that you say orally or in writing can and will be used against you in a court of law. You do have the right to an attorney when present at questioning and at all future proceedings. If you cannot afford an attorney, the court will appoint you one at the public's expense. Did you hear and understand your rights, sir?
I understand my rights, sir.
Thank you. Waive formal reading under plea of not guilty. Mr. Otis, I'm scheduling 2 court dates. You must attend both of them. Probable cause via Zoom, Wednesday, November 27th, last Wednesday, November, 8:30, 36th District Court, Judge Jefferson. You have a right to a preliminary examination in person the following Wednesday, December the 4th, in person, 8:30, Judge Jefferson, both 36th District Court. Understood?
Sir.
Not guilty, please on your behalf as the bond from the people.
Magistrate, we're asking for a $25,000 cash surety. We're also asking for a tether and house arrest. I understand this is being charged as a home invasion, 3rd degree, 5-year felony, as well as that additional MDOP misdemeanor. But how this is transpired and what's going on with the defendant right now really amplifies the danger. of the current situation regarding this defendant, the complainant, the community at large. This defendant is currently on an aggravated assault case. He was given a $50,000 personal bond. I actually argued for cash in that case. It was in front of the Honorable Magistrate Burton. He ultimately ended up giving this defendant $50,000 personal. That was a case where, and I'm sure defense counsel knows because I believe it's her outfit that's involved with the defense in that matter, where this defendant ended up putting the complainant in the hospital as a direct result of fracturing his clavicle and eye socket and causing that individual internal head bleeding. Now, Judge, this is something that needs to be noted here. Where that offense took place is the same place where this offense took place. And he had a no contact to go to this place of residence. This is where he allegedly ended up beating that other individual because that other individual was his neighbor. It was a upper and lower flat. That individual was on the lower flat. And this defendant
And he had no contact to go back to this Mendota Street on the ag assault?
Correct.
When was that arraignment?
March 15th of 24. I asked for cash. I was given.
Can I comment on this, please?
Yeah.
1 second, please. 1 second. What's going on with that case currently? Is it still pending or what's going on with that
It's
case?
still pending. There's a final pretrial December 19th of this year. Now, interestingly enough, the complaining witness has been present at each and every hearing at that point. So we have
That's still a personal bond? I don't mean to keep cutting you off, but did he was on a personal when he still at 50,000 personal when he picked this up?
That's correct.
Okay, keep going.
The complainant in there was 24 years his senior. That complainant was 54 years old. In addition to having to be admitted to the hospital for that assault, he threatened to kill that individual. And then he was arraigned, told not to go back to that house, not just by this court, but he and his family were evicted.
Not true, Your Honor.
Mr. Otis, hold on a minute, Mr. Otis. Hang on just a minute, okay?
Actually, I'd like to modify. Magistrate Burton usually says don't even go to the block. So it wasn't just the specific address. Defendant's right.
Mr. Otis, please stop talking just for a minute, okay?
Mr. Otis, please. Okay, go ahead.
So he wasn't even supposed to go in or around the block of where that residence was. But now we have allegations that he ended up going to the residence where that offense took place, broke into that house after he had been evicted. And then the police end up finding him in that house where he was previously evicted, where he was told not to go. He had broke into that house. The defendant apparently was detained, starts talking about killing and, you know, what potentially they're going to have to do to him. And then upon arrest, he starts assaulting himself in the police car, allegedly banging his head multiple times. And then apparently there's this idea that he's on suicide watch right after he ended up getting arrested. So the desperation is high right now. In addition to the idea that he doesn't follow court orders, in addition to the fact that
Are you aware, or could you shed any light? According to the investigator's report, there's 2 active personal protection orders. You know anything about that?
One is by the individual that he ended up beating to the point where he had to go to the hospital. That was the
that was at this same address.
Right. That was the individual that lived in the lower residence. The other one, I can't expound on that. It could potentially be the landlord, because apparently he's had issues with this individual and he was evicted. It would be natural to assume that, but we're not here to assume, so I can't answer that question. But Judge, I guess the long and short of it is, it's clear that there's a level of desperation on this defendant's part. He's assaultive, and he's going through an assaultive case. He's on a personal bond. He's breaking court conditions by going back to the place of incident now. So respectfully, we find him to be a danger, not just to the community, but to himself. So we're going to be
Thank
asking for, we're going to be asking for the cash with house arrest.
Thank you. Response.
So, Your Honor, I think it's Mr. Vinson's office that's actually prosecuting the pending misdemeanor. And to my knowledge, there have been no show causes or any other proceedings to indicate that the bond conditions have been violated. I am taking exception to the people's contention that Mr. Otis was prohibited from returning to his home. I believe that there was a no contact condition with the complaining witness. I would represent as an officer of the court that this has been a contentious neighborly relationship between Mr. Otis and the complaining witness, in that Mr. Otis is not living there anymore. I believe that should alleviate some of the court's concerns about danger at the hands of Mr. Otis to that complaining witness. There won't be any contact between them because now Mr. Otis doesn't have any reason to be there, but he's not been prohibited from being at that location, only from having contact with the complaining witness, and he's still innocent of that charge because he hasn't been proven guilty of anything, the misdemeanors, and certainly not of these felony allegations at this point. Your Honor, Mr. Otis does need some
I would like some clarification on that, because that's important to the court. If he was not supposed to go back to the location and did, or otherwise, that's important. APA, Ms. Stevenson's indicated that he didn't have a no contact with the location, and that's important to the court because that's where he alleged to have went back to on these allegations, which are non-assaultive, but if he's violating court orders, that's something I've taken into consideration. Do you have anything?
While you two were talking, specifically while Ms. Stevenson was giving you her request, I ended up going into the ROA. It says on the 315, no contact with the victim directly or indirectly. I referred back to my notes because this was my case, and I had requested a no contact with the individual or with the address, and I have a check mark, and that being that I would assume that Magistrate Burton would have given me that, because whenever we're talking about an assault to this magnitude, and because it was an upper and lower duplex, I don't know why or how, especially when he's already been evicted from that property, why or how he would be allowed to go anywhere near.
Right, I understand what you're saying, but what you kind of argued and what laid heavy on the court was the no contact provision placed apparently in by Magistrate Burton, and then if he violated that condition, that's concerning. If there was not that condition, or if we're unaware for sure there was that condition and there was no violation of going back to the location, it seemed differently, because here we have allegations that are non-assaultive. And the high concern is that he would have violated Magistrate Burton's order of going back to the location. But if that wasn't an order, I need to be clear on that. We don't want to assume things as you previously stated.
I can only tell you, and I respect defense counsel's argument. I request certain things when it comes to certain cases. I had requested a no contact with the address or the individual. I have a check mark against it. The ROA says no contact directly or indirectly with the victim in that matter, Judge. It just doesn't make any sense where there would be a condition that to allow this individual to go back to a house where the landlord previously had issues with, that they were attempting to try to evict him from, and that where an incident took place.
Does that landlord live there? Because if there was no contact with the victim, it could be at another location. If there was no, he's shaking his head no.
No.
When you said no contact indirectly with the victim, does the victim reside at this?
The victim of the first case, Magistrate, of the aggravated assault.
Right. Does he reside at the Mendota Street address?
Yeah, he was residing at the.
On November 16th?
I have no idea where that individual was residing at that time. I don't.
Okay, thank you. But so then we don't really know if he was in violation, even if it was indirect or not. If that complaining witness no longer resided there, then he wasn't in violation. That's kind of what I'm getting at.
In fairness to both defense counsel as well as yourself, and in full candor, I have what I have. We all know that the ROAs aren't always completely reflective of things, but I don't have anything otherwise other than what I ended up writing down, which I try to be meticulous on in terms of, you know, how arraignments and how they're issued. But I don't have anything. It would just be plausible. It would be logical to have a no contact with that. But I can't say anything otherwise.
Thank you. I appreciate you. Any response, Ms. Stevenson?
Your Honor, we would ask the court to consider high personal bond, and in that, it looks like the neighbor situation has rectified itself. No contact. We have absolutely no objection to a no contact condition, Your Honor, with the commission.
I just don't know how the neighbor thing has rectified himself. He got put, I don't know whether or not he's living there or not. I know that individual has appeared multiple times in court wanting to testify or having his testimony elicited. So I don't know how that's been rectified. I know we have allegations here of a landlord who's said previously multiple times that he's had issues with this individual. I know this individual wasn't supposed to be, per the landlord, let's just go with the eviction process, wasn't supposed to be there anyways. And it was the same place where the previous assault took place. So I don't know how anything could have been resolved, but I digress.
Thank you, both. So, Mr. Otis, you're both counsels advocated well. I appreciate both of your arguments. These are non-assaultive allegations. I have concerns, as indicated previously on the record, that you're on a personal bond for a very serious aggravated assault with a no contact provision, and it's unclear whether the provision was with the location or the individual, and that's been laid out on the record. I've reviewed the investigator's report on this matter. It's alleged that it looks like that according to investigators report, you shouldn't be at this location for a number of reasons. It looks like you have personal protection orders against yourself. According to investigators report, the landlord has, as recently as 4 days ago, changed the locks so your keys will no longer work. But it's alleged that you were there to get some of your property, and I don't see any assaultive allegations that took place on this matter, on these allegations. However, I have concerns that have already been addressed and placed on the record. And noted, unless Ms. Stephen can say otherwise, this allegation, though non-assaultive, did take place while you're on a personal bond on an unrelated matter, and that triggers MCL 765.6A. Being out on a personal bond and picking up new additional criminal allegations, the court's statutorily obligated to set some form of cash bond. For those reasons, bond on this matter is going to be set at a $1,000 10%. With the following conditions. During this bond, no use of any alcohol, no illegal controlled substance. You're not to purchase or possess a firearm or any dangerous weapon, no weapons. You will be filled with the GPS tether, placing you under house arrest if you're able to post before you release. And so to be clear, Mr. Otis, you're not to go back to the Mendota Street block in the city of Detroit. You're not to go back to that area. Is that understood?
I'm home, sir, but understandably so. Yes, sir.
Okay. And homeless or otherwise, you're not to go back to that Mendota Street. You're to have no contact with any complaining witness, including Mr. McCree. No contact is no contact of any kind, orally and writing through a third party at their place of residency, employment, or through any forms of social media. No contact with Mr. McCree. As stated prior, if you're able to post bond, you'll be filled with the GPS tether, placing you under house arrest. You're not to go anywhere near those locations. If you leave your residency or go anywhere near the Mendota address or Mr. McCree for any reasons, unless court ordered, that's a violation of the court's bond, subject to get you picked up without a warrant, have your bond conditions forfeited and or revoked. Ms. Stevenson, is that an unaffordable bond?
It is, Your Honor.
Mr. Otis, you'll receive an unaffordable bond redetermination hearing 2 days from today, November 21st, 2024, via Zoom at 9 a.m. Chief Judge McConaughey's courtroom or a judge in his stead. If you're unable to post the 1,010%, you'll see a judge on November 21st, 9 a.m. via Zoom to re-argue bond. Do you have any questions, Mr. Otis, on your court dates or bond conditions?
So you just gonna kind of elaborate on what my boundaries are again, just stay away from Mendota, the city of Detroit.
No contact with Mendota Street, no contact with any complaining witness, including Mr. McCree. You'll have a GPS tether placing you under house arrest. You're not to leave your residency for any reason. No alcohol, no illegal substances, and no weapons. Any other questions?
I don't have a residence, so.
Do you know when you're supposed, to be back in court, Mr. Otis?
Yes, ma'am.
Okay,
I'm sorry,
thank
I
you,
missed
Your
it on that top
Honor.
page. All right, thank you. Good luck. Thank you.
I appreciate you, Magistrate. Sorry to be exhaustive in that.
Never apologize. You're doing your job. Thank you. DDC, we'll meet you on the female side.
Yes, sir.
Thank you, sir.
Hey.
Your name?
Leora Ramsey.
Thank you, Ms. Ramsey, and good afternoon. One moment.
Hey, Greg, you like that 4-3?
Ms. Ramsey, you're on case 24060-532, People State of Michigan versus Leah Monique Ramsey, also known as Leah Ramsey, appearance for the people.
Lisa Quill, appearing on behalf of the people.
Thank you.
Annie Stevenson, appearing on behalf of Leah Ramsey, who stands mute, waives the reading of the information. As to the plea of not guilty, enter on her behalf, Ms. Ramsey has been advised of her rights, Your Honor.
Thank you. Wait, one more reading on her plea of not guilty. Ms. Ramsey, I'm scheduling 2 court dates. You must attend both of them. A probable cause via Zoom, December the 2nd. That's a Monday at 8:30, 36th District Court, Judge Taylor. You have a right to a preliminary examination in person, December the 9th, 8:30, 36th District Court, Judge Taylor. Understood, Ms. Ramsey?
Yes.
Wait, formal reading on her plea of not guilty as to bond.
Your Honor, in this matter, the people are requesting $100,000 personal bond, tether house arrest. And the reason, for the following reasons, this is a reissued warrant, Your Honor. This allegedly occurred back in July of this year. The original bond in August was $100,000 cash surety, tether only. Then it was, at redetermination, it was lowered to $100,000 personal bond, tether house arrest. And then on September 4th, the complainant failed to appear and the case was dismissed. And now we have the reissue, Your Honor. This morning, that trooper that was on here and had a breakout room with me this morning spoke to me. He notified me that he was part of the fugitive arrest team to locate Ms. Ramsey. She does not live in this city. She lives in another county. I won't say what her address is, but she lived out. They found her. They watched for her about 2 to 3 days. They could see her watching the troopers by way of her Ring camera. Then they located her in an Airbnb, and that, Your Honor, that the people are asking that tether to. This is a road rage incident in which allegedly that shots were fired. So based on that, and based on the fact that the trooper is of concern to make sure she is shows up for court, because it appears that she was trying to evade the police upon arrest, and that's why he showed up. And so the people are asking for a personal bond, but with tether house arrest, Your Honor, just as given to her in redetermination.
Thank you. Response.
We would concur with the people's request for personal bond. I think it is appropriate. Not sure about the tether though, because I don't know of any capias that occurred during when this case initially was being adjudicated. We have an address for Ms. Ramsey, and so I don't know if the troopers, left any requests for her to contact them or anything like that, but we're not aware of any capias history, and we do have the contact information for Ms. Ramsey. She does live locally, the information that we have. She does work, Your Honor, works from home. She has 3 children, also has some mental health issues, Your Honor, that do require medication. And I'm not sure, and physical health conditions that require medication. Well, I don't know if she's getting those during her time of incarceration, but we don't know anything about any capias history.
We don't know if she's getting her medicine. Please mark her file medical for the reasons stated by counsel. You just not know her, or is she not getting her?
I don't know. I don't know if she's getting the medication.
Thank you.
Okay, so I don't have any capias history, Your Honor, and we have the contact information for Ms. Ramsey. Again, I don't know that it is customary for, in my experience, for the Michigan State Police to let people, let a defendant know that they have a matter pending. I don't know that happened. So I'm not sure that we can conclude that Ms. Ramsey was engaging in any evasive activity. So I'd ask for personal bond. Thank the people for that recommendation. I ask the court to hold off on the tether at this point, Your Honor, and that there's no history of her not going to court like she's ordered to.
Okay, thank you both. These are, I do have, I've heard the advocacy from both parties. The people's indicated that there's some concerns on behalf of the trooper that's been placed on the record. I have no history of flight, as stated by Ms. Stevenson. These are a very serious assault allegations, specifically count 1 with a possibility of life offense. It's alleged that during a driving incident that the complaining witness took a photo of apparently the defendant sticking her hand out the window, firing several shots at the victim while driving in the city of Detroit in the center lane. And there's information that leans towards the likelihood of conviction that shell casings apparently were located. We have other information leaning towards the likelihood of conviction. This information, she had no capias history I'm aware of at the redetermination, and the bond was still $100,000 with the tether. Go ahead.
I don't want to interrupt you, but I was going to note she's been during the time she had no capias history, because she got a tether originally at the arraignment, and then the tether was continued at the redetermination. So it's likely there's no capias history because she was on a tether.
That's what I appreciate it, and that's what I was echoing, is that I feel the initial bond was appropriate, and that did ensure that she came to court,
and so there's no tether violations either. So if she had the tether on all that time and they never violated her, I guess the court should take that into consideration as well.
Absolutely, and I can all but imagine one of the reasons for the tether at the redetermination, there was no capias at the redetermination. This case was still going on. And it was, in my guess, I have similar concerns regarding danger to the community. These are allegations that she fired a shot at individuals in the city of Detroit while driving, and there's a high likelihood of conviction. So I noted there's no capias history. There was no capias history at the previous arraignment when a tether was included, and there was no capias history at the bond redetermination when the judge continued that tether. And I feel that it was an appropriate bond for those reasons. There's a likelihood of conviction. This is a life offense. I've heard that this is a reissue, and for those reasons, bond is going to be reinstated as recommended by the people, $100,000 personal bond. During this bond, there is no use of alcohol, no illegal controlled substance. You're not to purchase or possess a firearm or any dangerous weapon. During this bond, there should be no driving, Miss Ramsey. You're to have no contact with the telegraph, no contact with any complaining witness, including Miss Beck or Mr. Bell. No contact is no contact of any kind, orally and writing through a third party at their place of residency, employment, or through any forms of social media. Again, no driving, and prior to being released, you will be fit with the GPS tether given the concerns I've placed on the record, and that will be house arrest. You're not to leave your home for any reason unless court ordered or medical. If you leave your home or violate the curfew or have any contact with the complaining witness, you're subject to get picked up without a warrant, have your bond conditions forfeited and or revoked. Do you have any questions on your court dates or bond conditions, Ms. Ramsey?
So I have children that go to school, so are you saying I can't get my children back and forth to school? I have an 8-year-old and a 6-year-old, and I have a college student who I support. So I need to understand, like you saying, not leave my home at all?
Yes, house arrest. Yep, you cannot leave your home at all. That's accurate. Unless it's court ordered or medical reasons.
So what about my children? They're just supposed to miss school?
They don't have another way to get back and forth, a bus or
I
another
agree,
family
but
member to
they
take them.
no, they don't have no support. I'm their support. They live with me solely. They don't have their fathers around or anything. I explained that to the attorney before, and this was happened last time, and my kids were not going to school. And that's not fair to them. They deserve to go to school.
Well, Ms. Ramsey, these are allegations that you fired a shot at a complaining witness and while you were driving down the street, showcasing where there's a high likelihood of conviction. That's the reason that we're here with these allegations. Nothing to do with your children, but people, what's your response to allowing her to take your children to school?
Your Honor, I think it's appropriate bond based on the evidence that they found a shell casing, a fragment of the bullet, and he identified her in a photo show. So
I agree, Ms. Ramsey. I'm going to keep on as stated. This is an alternative to incarceration. This is a life offense that you could be in prison for the rest of your life. As an alternative to being locked up in jail, I'm going to order you under house arrest.
So, Your Honor, if it please the court, on behalf of Ms. Ramsey, would the court consider, and if this is a reissue and the allegations are from this summer, and apparently the tether was helpful so that it could monitor Ms. Ramsey's whereabouts, and we didn't have any tether violations, would the court consider allowing Ms. Ramsey only to leave her home for the purpose of taking her children to school and bringing them home from the school? Now, I understand, and I think there's a good nexus between.
I understand. How would she do this? Because I definitely do not want her driving. So she's not driving, period. These allegations took place when she was driving. So what sense would it make? How is she going to walk them to school? I'm just asking because she's not driving.
Yeah, I don't know how she would do that. And I agree with the court. I think there's a sufficient nexus between the no driving and the allegation. So I'm not going to have an argument against that. But at least if she is able to arrange for transportation through somebody else, at least if she could leave the house to take her kids to school and go pick them up, I'd ask for the curfew to work around that.
What is telling to me, though, the trooper found her living in an area, not in the city of Detroit, in another county. That's where they found her living. And then she went to Airbnb. So the children are not going to a local school. Okay, so I don't think anybody is here is being told the full truth. And so I think that this should be held over for PCC and further investigation. But based on what the trooper said this morning, he came on here, they're out there looking for her. So,
I'm comfortable. I've heard enough. Unless you want to tell me any party either more, I feel the bond is appropriate. I'm going to set it as stated. You have your hand raised. Counsel, you want to advise your client? Yeah. Yep, go ahead.
No, Your Honor, it's just a request that she be allowed to leave the house to take the kids to school and pick them up. If that's not going to happen, I don't have anything further.
That's not going to happen for the reason stated. You're not to be driving regardless. So I don't see any point at this time. And I have concerns. This is a late offense, high likelihood of conviction. And for those reasons, you're going to have to make alternative plans. You're not to leave your home. Anything further you want to tell the court or any questions, ma'am?
So, Ms. Ramsey, please, ma'am, at this point, I think you've heard the order of the court. If you have any questions though about when you're supposed to be in court, I think it's okay to ask those questions. Other than that, I'd ask you to hold off on anything else at this time.
I'm supposed to have another court date for traffic on the 9th as well, so I don't know if they're gonna run into each other, so I would like to clarify that.
You can address that at the probable cause conference. Yeah, and this is a felony matter, so this is gonna take precedent over any traffic matter, but you can address that at the probable cause conference or have your counsel address that if you're assigned counsel on any traffic matters. Anything further from any party?
Nothing further, thank you.
Not at this time. Thank you, Your Honor.
Thank you, ma'am. All right, you're all set, Ms. Rainey. Okay. Good afternoon, your name, please?
Danisha Gill.
Thank you, Ms. Gill, you're for a couple of reasons. Thank you, Ms. Gill. We'll go through them one at a time. First, you have matters, you have warrants for your arrest for failing to appear at the 36th District Court. On these matters, you'll be released on a personal bond, no dollar amount. I'm scheduling a pretrial via Zoom. You must attend December 17th, Tuesday at 8:30, 36th District Court, Judge Perkins. Understood?
Yes.
As with any criminal matter, Ms. Gill, you have a right to remain silent. Anything that you say orally or in writing can and will be used against you in a court of law. You do have the right to an attorney at questioning and at all future proceedings. If you cannot afford an attorney, the court will provide you one at the public's expense. Did you hear and understand your rights?
Yes.
Ms. Gill, this is in regard to ticket numbers SP 803342, February 15th, 2018. Count 1, drive unregistered untitled motor vehicle. Count 2, no insurance on a misdemeanor 04 Ford. Count 3, improper plates. SP 803344, February 15th, 2018, driver's license expired. SX 3687575, February 23rd of 2020. Count 1, drive unregistered motor vehicle. Count 2, no operator's license, multiple hours, no ops. Ticket number SP 1155041, March 17th, 2021, drive unregistered untitled motor vehicle. Count 1, count 2, improper plates. Count 3, no insurance misdemeanor on an 09 Chevy. SP 1177556, March 18th, 2021, count 1, drive while license not valid or improper license. Count 2, no insurance misdemeanor on an 09 Chevy. SP 1419971, January 20th of 2023, drive while license not valid or improper license, 2015 Chevy. Ms. Gill, these are all misdemeanor allegations that carry up to a $500 fine and or 93 days in jail as a maximum fine and penalty. Recall warrant set aside, please not guilty, please entered on your behalf. As a reminder, pre-trial via Zoom. Pre-trial via Zoom, December 17th, 8:30, Judge Perkins. Understood, Ms. Gill?
Yes.
Okay, let's get your hands down by your side, please, and state your name. You have
I have a question. So I went through, the program through Secretary of State Road to Restoration, and that's how I got my license back last year, but I was wondering, but how is it still on everything is still on my record if I went through the program to get my license?
Well, these are misdemeanor, let me answer. These are misdemeanor allegations. You have, Secretary of State does not dismiss misdemeanor cases. You have to show up to court and adjudicate these in some form or fashion. They control your driving privileges, so you may have taken some steps to reinstate your driving privileges, but these are open cases. You have to show up. If you don't, you're likely to get locked back up for not appearing. Show up to court, understood?
Yes, but they was going through the district court, so that's why I thought it was clear up. It was through Secretary of State and
So Ms. Gill, you have personal bond on those anyway, though, okay? So you'll be able to take care of that when you get to court. So now let's listen, just listen at this point, okay? You just have to go to court on those. You have personal bonds, so just listen right now, okay? Thank you, ma'am.
Thank you, Ms. Stevenson. And if you have any paperwork, always bring it if you want the court to consider it, but show up to court. You have an additional case, state your name again. State your name one more time, Ms. Gill.
Tanisha Gill.
Thank you. This is case 180444958, People State of Michigan versus Danisha Lynette Torreya Gill for the people.
Emily Ragland for the people, Your Honor. This incident is 6 years old, but it doesn't take away, the time does not take away from how assaultive that I believe that it is. This defendant was going to meet the complainant to exchange their daughter, and when he came outside from work, this defendant was with a male person who got out of the car and hit the complaining witness in the side of his head, falls on the ground, and this defendant goes up and stomps on his face. Once that was over with, she then continued to harass him, saying, "I'm going to stomp on your face again. I'm going to kill you. You can count on that." And he said he fears for his safety, and he's concerned about getting that interfering with his parenting time. Now, all that is 6 years old. I understand that, but I thought it was important to put on the record about what happened. We're going to only ask for a $10,000 personal bond at this time. And hopefully there's been no more problems since that time, Your Honor. I think, so we're asking for a personal bond. Thank you.
Thank
For
you.
the record, Your Honor, Janice Stevenson, on behalf of Danisha Gill, we'd ask the court to follow the people's recommendation for personal bond, Your Honor.
Thank you. And as to the arraignment,
Stands me ways of reading of the information as to the plea of not guilty be entered on her behalf. Ms. Gill has been advised of her rights. Thank you.
thank you. Court waive formal reading on her plea of not guilty on this matter, Ms. Gill. I'm scheduling a pretrial date via Zoom. You must attend Tuesday, December the 3rd, 8:30, 36th District Court, Judge Austin Garrett. Understood?
Yes.
Okay, and I'm unaware of any assault history. This allegation, very serious, as indicated, the APA took place back in 2018. For the record, it's noted you had a co-defendant, and his case was dismissed on or about April 28th of 2022 for apparently the complaining witness failing to appear. Some honor about that date. Your co-D was dismissed without prejudice. After a review of the investigative report advocacy from both parties, I'm following their recommendation. Bond is going to be set $10,000 personal bond. During this bond, Ms. Gill, no use of any alcohol, no illegal controlled substance. You're not to purchase or possess a firearm or any dangerous weapon. During this bond, no contact with the Westbrook Street in the city of Detroit, and no contact with the complaining witness, Mr. Jenkins. And that's no contact of any kind, orally in writing, through a third party at his place of residency, employment, or through any forms of social media. No contact with the complaining witness. Ms. Gill, do you have any questions on your?
Could I make a suggestion? And I'm sorry for interrupting. Perhaps we could change that to no assaultive contact. That way, if they still are sharing a child and doing something, they can continue to do that. I don't know if there's been anything since 6 years.
Thank you. Any objection from the defense?
None, Your Honor.
Okay, so I'm changing that, Ms. Gill, per the recommendation of both parties and given the age, to no assaultive contact. No assaultive contact, intimidation, harassing, threatening of any kind with any complaining witness, including Mr. Jenkins. Do you have any questions on your court date or your bond conditions, Ms. Gill?
No.
All right, good luck. Show up to court. Listen to the court. DDC, any males or females that you're aware of that cannot wait till 2:30?
No, sir.
DDC? Okay, thank you. Have a good lunch. Be safe. Thank you.
Thank you, Honor. Thank you. Thank you, Madam Clerk.
Bye-bye.